event. Hi, everybody. Welcome to our second Co-opting AI event in the fall 2022 program. I hope that everybody is having a good October so far. We just spoke about the fact that it is finally getting cold on both sides of the Atlantic. My name is Dr. Mona Sloan. I am a sociologist at New York University with an affiliation at the University of Tübingen in Germany, and I broadly study the intersection of technology, design, and society. Amongst other things, I am a fellow here at the NYU Institute for Public Knowledge, where I have been convening this Co-opting AI series since early 2019. Now, this series would not be possible without the generous support and sponsorship from, of course, the Institute for Public Knowledge at NYU, as well as the NYU 370-Day Project in Brooklyn, the NYU Center for Responsible AI at NYU Tandon, and the Department of Technology, Culture, and Society. And I want to thank everybody for their ongoing support of the series. Today's event is actually the 34th event in the series. I always like to say that because I'm so grateful that we've been able to run that many events despite all that's been going on. And this event today is dedicated to something that is keeping technologists, social scientists, technology users, advocates, and really everybody on their toes. That is, quote unquote, robot law, or new legal approaches to AI systems, which is an almost infrastructural topic if you think about it. But before we begin this conversation today and I introduce our wonderful guests, I want to acknowledge that I'm standing on the unceded land of the Lenape peoples. And I ask you to join me in acknowledging the Lenape community and perhaps the indigenous communities on whose land you may be standing right now, and to commit to beginning the process of working to dismantle the ongoing legacies of settler colonialism. Now, as AI systems affect different sectors and professions, regulators all over the world are forced to mitigate the potentially harmful effects of these systems. This is particularly true for what we call high-stakes situations where AI affects lives in a profound way. For example, employment decisions, education, or criminal justice. And so we all at this point are acutely aware of the many potentials that AI harbors for discrimination in these contexts. Now, there are various ways in which regulators and lawmakers approach the challenge of mitigating these harms. For example, the EU General Data Protection Regulation, which is a regulation that came into force in 2019, so a little earlier. That's the one that's responsible for you kind of clicking a lot of buttons when you go onto a site when you are in Europe, for example. There's also the Canadian Directive on Automated Decision-Making, and there is the fairly recently introduced US Algorithmic Accountability Act, which calls for conformity assessments, algorithmic impact assessments, and other forms of documentation related to the design, but also the effects of AI. Similarly, and importantly, the yet to be enacted EU AI Act proposes an AI risk categorization framework that regulates different kinds of AI in different contexts in different ways. And in May 2021, the White House executive order issued by the Biden administration included a section directing the National Institute of Standards and Technology, known as NIST in the States, to initiate a pilot program informed by existing consumer product labeling programs to educate the public on security capabilities of Internet of Things devices and software development practices. And they're also working on a now public risk framework that you can actually look at online. There are, of course, cultural differences in approaching AI regulation, and there are various domains of AI applications that attract heightened regulatory attention. Hiring is one of them, and employment, of course, but also law enforcement and criminal justice, and also autonomous driving, so safety on our roads. There are also differences between working with policymakers to conceive of and enact AI laws and actually trialing them on the ground. And with today's event, we are bringing these differences into one room. We will be discussing the legal implications of AI and AI-driven robots from both a European and a US perspective. And we're going to be looking at this from both applied and theoretical perspectives. And I am absolutely thrilled and honored to host two robot law experts for our conversation today. Please join me in welcoming Dr. Erik Hilgendorf, who's joining us from Germany today, and Juyoun Han. Starting us off will be Erik, who is a professor of law and the chairman of the Department of Criminal Law, Criminal Justice, Legal Theory, Information and Computer Science Law at the University of Würzburg in Germany. He is also a member of the global faculty at Peking University Law School. And he holds an MA in philosophy, modern history, and law from the University of Tübingen, where he worked on the development of parliamentary freedom and speech in Germany. After that, he received his PhD in philosophy with a thesis entitled Argumentation and Jurisprudence, and then a PhD in law with a thesis on criminal law liability for producers in the Society of Risk, for which he actually received an award from the Reinhold and Maria Teufel Stiftung. And yes, this gentleman completed 2 PhD projects. After that, Erik habilitated, which is another big thesis project in Germany or in the German academia in the fields of criminal law, criminal procedure, and legal philosophy, with work on the distinction between statements of facts and statements of norms in criminal law. He became a full professor of criminal law and related fields at the University of Constance in 1997, and then he became the dean of the law faculty there. And in 2001, he moved to the University of Würzburg and became the chair of the Department of Criminal Law, Criminal Justice, Legal Theory, Information, Computer Science Law. He also served as a member of the European Commission's high-level expert working group on AI, which produced the work that is the basis now for the big omnibus regulatory framework that we're all waiting for from the European Commission. Welcome, Erik. Following Erik will be Juyoun Han, who is a partner at Eisenberg Baum, where she is directing the firm's digital technology and human rights group. As a litigator, a tech enthusiast, and a human rights advocate, she's excited about innovative technologies and hopes to harness the law to promote fairness and accountability in a design in society. Having served as a law clerk for the Honorable Stephen Tiscione and the judicial intern for the Honorable Kiyo Matsumoto in the U.S. District Court in the Eastern District of New York, Juyoun possesses a deep understanding of courtroom advocacy and judicial procedures. At Eisenberg Baum, she counsels clients throughout trials and appeals in challenging cases as varied as street art litigation and anti-discrimination lawsuits as part of the firm's Deaf and Hard of Hearing Law Center. She frequently collaborates with advocates and public interest groups who share a common passion to eradicate inequality. That's how we met. Previously, she was invited to speak at the World Congress for the World Federation of the Deaf in Paris, and she has volunteered at the International Justice Mission in DC to combat international sex trafficking of women and children, and she's worked at the UNESCO Korean Commission. Before law school, Juyoun taught high school and college level students in South Korea. She received her JD from Georgetown Law and her BA in Psychology and International Law from Handong University in South Korea. Welcome to you too. Thank you both so much for joining. 2 words about housekeeping. We will hear, as per usual, from our panelists for about 10 minutes. Then we'll have a panel discussion, and then we will bring the audience into the room. So please make use of the Q&A function in Zoom. Put your questions, your comments in there. We'll bring them in as soon as we can. And with that, I'm going to toss it over to Eric. Thank you both so much for joining us today.
Yes, hello. Thank you for this wonderful introduction. I feel a bit flattered and nervous, and you realize my English is far from perfect. If it's difficult to understand me, just stop me, and I will try to do it better. So I prepared a short paper, and I will give you the basic information from this paper on robot law in Europe and in Germany. Around the world, the topic of artificial intelligence is increasingly attracting the attention of legislators. In many cases, established legal rules can be interpreted in such a way that AI is also covered. Increasingly, however, attempts are also being made to create new rules tailored to AI. For Germany, 2 sets of rules are particularly important that are aimed at regulating AI and robots. First, the AI regulation of the European Union, Mona just mentioned, which has been only available as a draft since April last year. And secondly, the new regulation on autonomous driving in Germany, which will or has already come into force in the summer of last year. I would like to briefly introduce both sets of regulations. So let's begin with the draft AI regulation. Based on the proposals of the EU high-level expert group on AI, in which I myself participated as a member of the German delegation, and the EU white paper on artificial intelligence, as well as the debates that followed, the European Commission presented a proposal for a regulation of the European Parliament and of the Council laying down harmonized rules on artificial intelligence, the so-called Artificial Intelligence Act, in April 2021. The proposal aims at nothing less than the world's first comprehensive legal regulation of artificial intelligence. The proposal has attracted widespread interest in Germany and in Europe, with supportive and critical voices roughly balancing each other out. The Commission justifies its proposal by stating that the use of AI to improve forecasting, optimize processes and resource allocation, and personalize service delivery can benefit society and the environment and provide competitive advantages to businesses and the European economy. In particular, AI could be used in the sectors of climate action, environment and health, public sector, finance, mobility, home affairs, and agriculture. However, the expected socio-economic benefits would be offset by new risks or disadvantages for individuals or society. And that is why, as they say, regulation of AI and its application is needed. By far the largest space is taken up by the regulation of high-risk AI systems. These are to include, for example, systems used for real-time biometric remote identification of natural persons, systems intended to be used as security components in the management and operation of road transport and in water, gas, heat, and electricity supply, systems intended to be used for decisions on access or allocation of natural persons to education and training institutions. And AI in the context of mobility is also considered a high-risk system. These high-risk systems are subject or are to be subject to a whole range of requirements, which are set out in more detail in the draft. These include, for example, the establishment of a risk management system, special data control and data governance procedures, the requirement of technical documentation, certain record-keeping obligations, ensuring transparency and the provision of information to users, and ensuring human oversight, meaning human control. In addition, there is a requirement of accuracy, robustness, and cybersecurity. This attempt to comprehensively regulate AI systems seems fundamentally welcome. In order to place such systems on the market, legal certainty and consumer confidence, and thus a clear and comprehensive legal framework are required, at least from a European perspective. However, it seems that the draft overshoots its own goals in quite a few places. The understanding of AI systems on which the draft is based is extraordinarily broad, so that numerous companies are directly affected. This raises concerns, in particular because the regulation of high-risk AI systems appears to be extraordinarily complex, bureaucracy-prone, and burdensome to some or for some companies. The fact that the European Commission is to be empowered to unilaterally expand the list of high-risk systems is hardly compatible with the goal of legal certainty. And the relationship to freedom of research, which is a basic right, for example, in the German constitution, must be clarified. The numerous requirements for manufacturers and providers of high-risk systems, which overlap to a large extent with the requirements for product liability and lead to unclear duplications, are also not entirely convincing. Duplication is also to be feared with regard to regulations and evidence in the context of finance. For the automotive sector, there are already approval requirements in Europe, particularly for type approval, whose relationship to the new requirements prescribed for high-risk systems would have to be clarified. And the relationship of the planned regulation to the GDPR also raises a lot of questions. Now, my second topic, and I will be quite short here, is a new law on autonomous driving in Germany. This new law on autonomous driving has been in force in Germany since summer 2021, so it's 1 year old. What is surprising about the law is the extent and level of detail of the standardization. It raises highly complex issues relating to the regulation of new IT technologies and the interaction of humans and machines, which extend far beyond autonomous driving and will need to be discussed intensively in the coming years. The basic idea of this new law is that motor vehicles without drivers and even without an assisting reserve driver are allowed on German streets as long as the three following conditions are met. First, the motor vehicle can perform the driving task independently. Second, it moves within a specified operating range. And third, it has technical equipment that can deal with problematic situations autonomously. In addition, there has to be a technical supervision that is able to deactivate the vehicle in emergencies and, in addition, to approve special driving maneuvers. There are a lot of interesting details in the new law. For example, the car must be able to deal with collision avoidance problems, including the trolley problem, all by itself. All in all, the new law contains what is currently the world's most advanced regulation on automated driving in regular operation. To me, the reform appears to be basically convincing. It is a big shot that goes far beyond a simple amendment to road traffic law. As such, it could form a basis for regulating autonomous driving, not only in Germany, but possibly throughout Europe and perhaps even beyond. Thank you.
Thank you so much, Eric. Much appreciated. I am going to toss it over to Juyoun for her contribution, and then we'll start our panel discussion. And audience members, if you have questions that pop into your head, pop them into the Q&A and we'll get to them.
All right. Thank you so much, Eric, for your contribution. My contribution, I think, is along similar realms, but I do approach it from a little bit of a different angle. And I think that our discussions will actually have a very robust discussion in terms of the issues. So I lead the Department of Digital Technology and Human Rights at my law firm, and I do a lot of litigation that relates to civil rights. So what is commonly known to us as civil rights litigation that has anything to do with the area of technology, whether it be any kind of discriminatory decisions that are made and used and implemented in different fields, like Mona was saying, in housing, in hiring, in lending decisions, in practically all aspects of our lives. And in very practical ones like, driving and when to go, when to stop, right? The basics of driving, if I understand correctly. I'm a horrible driver. But these types of intersections of how our lives are more and more reliant upon decisions that are not only touched by human beings, but also by the use of machines that are essentially tools and assistive devices to enable our living, but possibly growing more than that in ways that we may not imagine or know. So anything that has to do with, technology and civil rights are topics that are of my interest and that we bring to courts if there are harms that arise out of it. And if those harms are societal and mass scale, then we do develop, class action litigation based upon consumer protection principles, based upon, anti-discrimination, federal and local laws and things like that. So I want to kind of canvas through, and because this is kind of the motive of provocation, meaning that I would like to provoke your thoughts, I want to sort of share with you the kinds of questions that I often think about that are raised in the cases that I litigate in this era. The first question that I had when I was shaping and reconstructing my litigation department was the name of the department. It used to be, until last year, Artificial Intelligence and Data Privacy Department, because those are kind of the technical terms used in the law and used in data science as to the fields of science that we look at. But then I realized that essentially what we're doing is to kind of define the role of technology and define the lives of humans and the kinds of rights that we have as humans that are distinct from the artificial cognition of machines and robots. And so instead of using civil rights, which is a broader term, I kind of wanted to bring it to the accent on human rights. And that's one of the things that I wondered, is it clear? What do we mean by human rights? What do we actually distinguish when we say humans versus robots? Are robots completely devoid of human origin? Is it completely devoid of human effects? Is it not a reflection of how we humans, make our decisions and construct our society, in the sense that the training data that a machine receives is based upon human decisions? So those are the kinds of thoughts that I had, which is, I guess, more philosophical. And then more legal, questions that I often think about is, how are human rights affected by robot interactions, decisions, and robot deemed assessments? And are the human rights, for example, the fact that in a housing scenario that our profiles as desirable renters can be deemed in certain ways by a robot, and in certain ways differentiated by another renter applicant. And the fact that robots have a role in making those decisions, does that affect me? Yes, it's probably all agreeable. But does that affect me in a different way than when a human rental assessment manager is looking at the applicant profiles and making discriminatory decisions? And what are those differences? Do I feel more emotionally vulnerable because it is a human interaction, or do I not feel more emotionally vulnerable in human versus AI decisions? Those are the kinds of things that I think about when we talk about damages and harm in the legal sense. And another thing that I think about is, if robots had made decisions that were discriminatory in nature, who is to be held liable? Is it the developer of the programs? Is it the operator of the programs? Is it the seller of those programs? And how do we know who is liable? It is a construction often of many people, and it's perhaps the banality of evil. It's not one person that has the wherewithal to direct what the robots should be doing and how far those implications of the decisions can go. So then, the accountability scheme has to take into factor all of those, modes of construction that go into making a robot decision. And another thing that I think about is, how do we know the motivation of a robot or a machine decision versus the motivation, the knowledge and intent of human beings? And maybe this is a question that Eric might know better, because, the criminal mens rea standard, what we often call the criminal intent, the motivation of the crime, those types of motivations in a civil sense, discriminatory intent and the knowledge, right? How do we know how a machine had been motivated? And more so in the court, how do we prove it? Is there a way we can prove it through evidence? So those are all questions that run through my mind in the course of litigation. One of the most recent litigation cases that I do think is relevant to both lawmaking and in judicial decisions is the fact that we had looked into medical algorithms, which are formulas that determine, specifically in this case, how your kidney health can be assessed and how you can be diagnosed for chronic kidney disease. And, there are markers and ways that your creatinine level in your blood factor into the decisions and levels and stages of chronic kidney disease. And all of those things are put into a formula, but race is also a factor that can elevate or decrease the level of risk that goes to the diagnosis of kidney disease. And it's not just that the assessments were given a score that was used in clinical settings, which itself is an issue that needs to be very closely examined, but judges were using this to determine the eligibility of prisoners or incarcerated individuals to deem them eligible for compassionate release during COVID times, based on the health risk scenario. And the compassionate release statute under federal law is a very humanistic scale. It's not just, here is all of the numbers, and if you pass this number, then you get compassionate release. By definition, compassion, means something a little more human level, a little more empathetic. And perhaps our conception of robots and their minds are not there yet. So this very complex, very multi-factored prong for compassionate release was actually incorporating a decision that was made by an AI, a formulaic decision about one's health score that had a race factor built into it. And so that meant that a lot of people who were African-American were not diagnosed in the same way that non-Black people were diagnosed. And so those bring up lots of questions about, how do we understand the interaction between AI decisions and humans? So what kind of real harm is there? And how do we actually prove that the AI was liable or accountable, should be held accountable? And who is behind that? Who is behind the development of the AI and behind the decision-making based on the AI? And there's recent regulation that is being developed to address clinical algorithms and accountability structures under Section 1557 of the Affordable Care Act. So those things are very interesting issues to look into. And the last thing that I will mention is that this topic of AI versus human is also a lively discussion topic in art law and copyright law. Earlier this year, there was a decision by the Copyright Office where they examined and reviewed a copyright registration application by AI-generated work. And this work was something where there was no human contribution. It was it was purportedly just AI-generated artwork. And the Copyright Office said or interpreted the Copyright Act to say, for an artwork to be original enough to be able to be registered, it has to have human authorship and not AI, purely AI authorship. It's not to say that humans who use AI or elements of AI to create artworks will not have the right to register a copyright. They can. Here was a distinct scenario where it was purely AI generated, and the contributor had said, I had nothing to do with it. This is purely AI generated. And so that made the Copyright Office kind of take a step back and say, well, authorship, and human originality means that something derived from the origin of human beings and not anything else. And so we will not consider that original enough. And that's very interesting because, we kind of rely upon AI to make fundamental value decisions in our society in many ways. But in the way that we see art and aesthetics, we definitely kind of draw the line and say, well, is it human? Is it AI? How do we define creatorship? How do we define, original artwork? How do we define authorship? And those things we seem to have a better way, at least, or a simpler way of defining. And so I just wanted to kind of throw that out there as part of the provocation. Looking forward to discussions, questions, and contributions from everyone. Thank you.
Thank you very much, both Eric and Juyoun. Very much appreciated. I will start with a question for both our guests today. And again, asking the audience to pop questions into the Q&A. I see we already have 2, so feel free to add more. And I am going to start with before I have a few very specific questions, but I'm going to start out with a broad one for both of you, which is about challenges that you see in terms of AI regulation. Both of you already pointed to that based on your area of expertise and your experience. But I am very curious to hear specifically from both of you from a European and a US American point of view, what are major challenges in regulating AI that you see, the most pressing ones that you see and that you maybe experience in your professional practice? Eric, maybe you can go first.
Okay, it's a difficult question. I would say the European attempt to regulate AI in advance is in itself interesting, but it's very a complicated thing to do. It's not quite clear whether it can be successful because this area is developing so fast. So some people say we should just wait and do nothing. And then, of course, we have tort law, we have criminal law. If something happens, there will be damages paid and there will be the criminal law. But that's not the way Europe is doing these things. And I was, as you said, part of the expert group that tried to lay the foundations of this new regulation. And it was this point we discussed most hotly. And the people from Britain, they were very skeptical of regulation. And people from industry also were skeptical of regulation. But especially the Germans, I have to say, the Germans were in favor of regulation, and they succeeded to convince the majority or to start the process of regulating. But many of us now think that this new draft of AI regulation has gone too far, as I tried to show in my short paper.
Thank you so much. I have a follow-up question on that, but before I ask that, Juyoun, challenges.
I'm very intrigued by what Eric had said, but as the challenges, I think in bringing litigation, detecting whether or not there is harm arising from the use of a specific algorithm is always a challenge, as opposed to discrimination that happens on a human-to-human basis, right? If I were to walk into a store and I was kicked out because I am Asian or I'm female or whatever it is, then I know that I've been discriminated. But oftentimes the kind of biases and discriminatory decisions that must be examined are not done so until it's far too late. And by the time we belatedly detect those harms, then so much has already been done on mass scale that then the challenge is remediation. How do we bring that all back? And so I kind of personally think that the trying to get ahead of the game and be a little bit too austere, perhaps, in regulation is a good step. But yes, those are the challenges that I see.
Thank you both for that. Eric, do you want to chime in here? Go ahead.
I just wanted to say it's. I'm glad that the American colleague supports the German perspective. Yeah, maybe you have German genes. Yeah.
That is actually a good cue for me. So I am intrigued by, of course, the notion of cultural differences. As a sociologist, that's kind of what I'm also interested in, but I'll park that for a moment. You both spoke about the tension between, I'm just going to call it ex ante and ex post, right? Like we're kind of preemptively regulating versus we're waiting for the harms to occur, and then we'll go to court and see what happens and kind of let's see how the cookie crumbles, as it were. However, both of these are based on abilities and techniques to identify harms and then link those harms back to AI systems, or those systems that we call AI. And Eric, you just said, well, it's moving so fast, and both of you are dealing with that problem, right, in your everyday practice. So my next question or follow-up question for you is, and then we'll turn to the audience who's wonderfully active in the Q&A. What do lawmakers actually need to know? We all talk about harms, but what are the specifics? Or are there any specific conversations that are happening among lawmakers, AI regulators, and litigators? Juyoun, you were a litigator, right? Like, what are the kinds of conversations that are happening around AI harms, and what do we actually need to know, given that harms seem to be, where everything focuses, whether that is the, preemptive regulation and trying to, create safer spaces, or litigation later down the line. Maybe Juyoun, we'll start with you.
I think what you're fundamentally getting to is the same challenge that I had been raising, but to make it a little more concrete, the public, the lay public really does not have enough to even suggest to court that there is something fishy going on, because in order to show to the court in a complaint, we have to show that there is a plausible inference to be drawn that there is harm occurring from a specific use of AI harm, and because a lot of the machine learning processes, the algorithms, the training data sets, and what have you are, very closely protected for good reasons, right? They're proprietary information. They're part of the making of an entire enterprise and service and product. So in order for the public to break that barrier and to bring something to the court indicating that it's beyond speculation that there's harm arising from the use of a certain product that's based upon AI decisions, there needs to be a large collection of data and a very high expertise by knowing and learned individuals to even get to the level of acknowledging that there's something perhaps discriminatory going on. And, for regulators, I think there are a lot of regulations, including the Section 1557, that will either say that, when there's a request by a member of the public to investigate a certain issue, that the appropriate agency will open up an investigation on their own. And what does that investigation entail? Does that mean that that regulatory agency can get more than a lay public member can? Can they actually get to the training data set to understand, if there's an indicator or proxy use that can be discriminatory? So what is the level of access to the information that an agency will have versus a member of the public? And what kind of expertise will they need to employ to be able to do the due diligence that's required? Those are, I think, topics that need to be concretized as we look into regulatory efforts.
Well, I totally agree, if I may. It's my round now. Totally agree with Juyoun. So I would also like to add some practical aspects. At least in Germany, the lawmaker would often wait for practical cases to happen and only then start to improve the law. So we have already a quite sophisticated legal system, and the lawmaker is reluctant simply to work on that on the basis of speculations. To give you a concrete example, we have an elaborated system of road traffic law. And then now 6 years ago, there was a first accident with a partly autonomous system. It was a car from a German car maker, famous car maker, but I won't mention the name. And this car had an autonomous collision avoidance system. And this car went the high speed into a small village not far from my hometown, Würzburg. On the steering wheel was controlled by a man around 60. And this man suffered a stroke when the car entered the village, and the car swerved aside. And normally this car would have come to a stop in the bushes outside the village. But of course, this German collision system functioned perfectly, and it brought the car back on the street. And then the car went on for nearly 2 kilometers until it came to the middle of the town, and there it killed a young lady and her daughter, and the husband was able to jump aside, and he was hurt badly, but he survived. And then the car crashed on a wall, came back, and came to a standstill, to a stop on the other side of the street, and the driver was unconscious all the time. So you can say it was an autonomous system that killed these 2 people. And it was a new case, and the state prosecutor asked me what to do about that. Yeah. And from a civil law perspective, it's simple. Yeah. When it comes to damages, according to our law, damages have to be paid by the holder of the car. The holder of the car had to pay the damages, meaning the burial costs of this woman and the child, and the medical costs of the man. So that was no problem. The problem was that the surviving man said, I want to know who killed my wife and who killed my daughter. And I'm not willing to accept just a small sum of euro for the burial. I want to know who's to blame. And this is where criminal law came in. And then the state prosecutor tried to analyze who could be held liable from a criminal perspective. Of course, not the car. This is absurd. Yeah? According to German perspective, the car cannot be held liable, but the producer of the car. And then they discussed this for quite a long time. And the car producer, the company that had produced the car, argued, we know that this collision avoidance systems is not perfect, but we made a lot of tests, and we can say our collision avoidance system is better than American, or not better, of course, yeah, but as good as American collision avoidance systems, and it's better than the East Asian collision avoidance systems. So they argued they did all they could do. They could do nothing more. If they wanted to introduce collision avoidance systems into the German market, this was the best possibility. And the lawyers, the state prosecutor, was convinced by that argument, and they argued it was not a case of negligence. Therefore, no negligence and no criminal prosecution of the company. And this case was considered of high importance for the law making process and the lawmaker, law producer. They said at the moment we do not need a better criminal law and no better civil law for car accidents caused by autonomous vehicles, because the existing law seems on the whole to function. So that would be an example of how lawmaking is done here in Germany.
Thank you both for your very insightful responses to that and bringing very concrete cases and examples to the table. Juyoun, did you want to add to this before we turn to audience questions?
I think I do. Regarding the ex ante and ex post type of an angle that Mona, you had addressed, at a certain point, I wonder if we're all guinea pigs, if we're waiting for harm to happen and to be litigated. And I think there's a level of discomfort. And then I guess the comforting factor is what Eric mentioned in terms of, well, it's the best that can be done. It's the best in the industry standard, but who defines the best, right? And then, you raised a question that the father in this case had raised, like, I want to know who's accountable for this. And I think in the legal sense, accountability involves always, in our current view of the law, a human actor. And I think it's quite dissatisfying for a person to be told, oh, it was a machine decision. The machine is pretty well constructed. It still does not give the satisfaction of accountability. And I wonder if that's the difference between human AI interaction and harms that derive from that versus human to human, and that in a human to human context, there is someone who can be saying, hey, this was the best and I apologize, or something like that, right? So I think there is still an element that we consider kind of fundamental to the law. Certainly, legal certainty is fundamental, but also the way of accountability and the ability to articulate harm, I think is another factor, to think of, and perhaps cannot be addressed in any one case, right? So that's what I wanted to follow up with.
Thank you for that. I am going to turn to the audience who have a whole bunch of questions. So I am going to ask each of you to answer. I'll point different questions to each of you. The first one is from actually a dear colleague at NYU, Alan McFarlane, who I think is referring to the conversation we were just having. And he is asking about professional associations and their role in this space. Do they have any bylaws to address this issue? That is a great question I've been wondering about as well. How are they influencing or not influencing these types of outcomes? And so very, very briefly from each of you, super short because we have a bunch more questions. Eric, if you could go first, professional associations.
Yes, professional associations are participating in the process, from consumer protection groups to the car companies and civil rights organizations. And there's a strong tendency in the press to look at this process very critically, because lobbying is a very bad word in Germany. So the car industry is under a lot of pressure not to use ways of influencing the parliamentary decisions that are not okay.
And I would similarly echo that professional associations have a dominant role. For example, in the case that I mentioned regarding kidney assessments, it was really when the National Kidney Foundation and the American Society of Nephrologists took the position that race should not be used as a factor for kidney diagnosis, that then, brought up a rise of regulatory efforts and much more need for investigations, and kind of validating the fact that medicine itself is not value neutral. So professional associations can easily be the fallback for a lot of these decisions, saying, oh, this is what everybody does. At the same time, when the associations change their standard, then it does have a strong effect and is a main contributor to advocacy as well.
Thank you so much. I'm going to take that as a cue to ask a question that Sila Tafti is asking, which is related. I'm going to ask both of you to, again, give brief answers. And they're asking or stating that it seems that producers of AI technologies and regulators of AI are very involved in lawmaking, which is a fair observation. But and they're wondering in which ways are legislators gaining public opinion on the matter? What are some of the ways that the public have an input? I know that the European Commission had specific ways of doing this. So maybe Eric, you go first, and then Juyoun, maybe you can speak to this as well briefly.
Yes, well, this regulatory process started all in 2018 with this high-level group. And the high-level group was consisted of 3 groups of people from the academic area, like me, people from NGO people, NGO activists, civil rights activists, and the third group was representatives of the European and American companies. And because of this, there was from the beginning a certain influence of companies, but on the other hand, companies were ready to accept these new regulations. For example, Bosch company was very closely working together with the NGOs to argue for human rights in AI. And then what the high-level group did was not yet lawmaking. The lawmaking process on the European level began later, and in these processes, normally the European public, has a chance to contribute. And of course, not everybody contributes. And again, organized groups will be quite active, even or also companies, but also the general public. And then when it's very close to the real law, then the press normally will take it up, and there will be a lot of articles in the newspapers and journals and so on. And at least the people that read these kinds of texts will participate, and then Parliament will decide. So I would say on the whole, it's an open process. Everybody can contribute, but in reality, certain groups have a far greater impact on the law than other groups.
That's super interesting. And I think the processes may look a little different, but are fundamentally similar here as well. I want to, in addition to everything that Eric said, I do want to point out that on the agency regulation and rule setting level in the United States, as you all may be aware, there's a notice of proposed rulemaking process, where if an agency is trying to regulate a field and set out, new regulations, like the ones that I mentioned about clinical algorithms coming under the purview of Section 1557 of the Affordable Care Act, the HHS, in making those rules, have to propose the rules that they have in mind, and then give a comment period to the public, where anybody in the public can go online on the Federal Register and leave a comment. And it can be a wonderful opportunity for people in academia to really give solid feedback based on their disciplines, and it allows for interdisciplinary efforts as well. And similarly, on the local level, the fact that whenever a new surveillance technology is about to be used or proposed to be used, the NYPD will publish it, and will have to receive comments from the public per the rules. And so that's another opportunity where, small contributions from everyone, anything from 3-sentence opinions about how you feel about it to, thesis, could be acceptable. So I think those are very timely ways to get involved with specific issues that are coming up for regulation.
Thank you both for that. And if I may add, there's also work with advocacy groups that already exist in both places, as it were, who also have kind of fairly well organized ways of working with regulators as well. I'm moving along with our wonderful Q&A, and I have a question for you, Eric, from Johannes Ketzer, who is asking, as a member of the European High-Level Expert Working Group, such a long term, do you think that the European Union, not the Commission, the Union, can come to an agreement of the meaning and scope of fundamental rights, such as human dignity? And they're wondering how important is such a shared understanding. Would regulation of AI even be possible with differences in this area?
Yes, thank you for this question. I think it's very interesting, but also very difficult. I believe, it's my impression that human dignity as a concept is much used in a much more differentiated way in Europe than it is in America. I think in America it's kind of taboo word, or people are a bit reluctant to define it. But in many European constitutions, we have human dignity, and there has been lawyers' work for years or decades to define what human dignity means. And in this high-level group, I was able to smuggle an article written by me on human dignity in the official text. So if you look at the results of this high-level group, there were four papers. The first paper is on the basics, on the philosophical part, and we start with the idea of human dignity, and the message is all regulation must be supporting this idea of human dignity, which means more or less that the human being must be in the center of regulation. The needs of humans must be in the center of all regulation. Regulation should not be a regulation for big tech companies. It's not a regulation for business, for the economy. It's of course not a regulation to improve state power. It should be a regulation for citizens and their concrete needs. And then this aspect, or this idea of human dignity, is differentiated into the human rights, like liberty, freedom of speech, and so on. And we consider this whole area as kind of, I think, pyramid, the English word, with human dignity on top, and then the human rights, and then law, and then concrete decisions by officials. And we talked quite a lot in our group on this topic. So I can say we consider human dignity very important, and we also try to give it a certain clear-cut meaning.
Thank you for that. I have a somewhat related question for you, Juyoun, from Lee Nelson. And it is somewhat related because it speaks to kind of cultural differences in general approaches to the law and regulation. And we just heard about the significance of dignity or human dignity in the European context. And Lee Nelson are asking, this is a longer contribution, so I try to synthesize. They are wondering whether it is possible, essentially, to effectively regulate AI, especially in high-risk areas, without concepts and practices such as abolition or absolute refusal. And at least until I can be proven to not add or perpetuate pre-existing problems. And they're wondering to what extent a quote-unquote precautionary principle is actually being implemented in AI regulation vis-a-vis this issue. So Juyoun, maybe you can speak to that.
Yeah, you know what, I think if I may take the editorial discretion of how I understood the question, you know, the first thing that popped into my mind is, yes, discrimination and minoritization and even harm is very culturally contextual, right? So on the one hand, you know, the ways that we've defined harm based on gender or sexual orientation and things like that have changed very rapidly over the course of years, that perhaps if we were to look at a decision that was made, 10 years ago versus now, it could look very different in terms of how we would have defined harm then versus now. And so I guess the real question is, how right now can we assess impact of a certain decision that could occur in the future, knowing that there will be many cultural changes and contextual understandings that change over time, especially when it comes to discrimination, rights, and the ways that we are able to acknowledge and articulate harm. And I think that's a very difficult question. And I think about how, like in environmental studies, we do longitudinal studies about how a particular matter that's inside, water or ground can have, latent harms, and later, if people find out they were harmed by certain things, right? And those concepts certainly are needed, though it's not perfect, right? We would love to know perfectly what the harms and impacts will look like in the future. But to the best we can, the recurring longitudinal assessments and reassessments have to be done in the process of AI decisions and development of decision-making tools too, because for that exact reason, because we may deem something to be safe now and something to be fair now, but a year later, it may be different. So unless we have continuous longitudinal harm assessment that's done both internally and through external transparency mechanisms, it'd be very hard to have a satisfying answer to that.
Thank you, Juyoun. I'm just have a quick follow-up question from Ellen McFarlane here, who's just asking, how bad is the problem? On a scale from 1 to 10, the problem of AI perpetuating existing and historical systems of oppression from your applied practice.
I have to borrow from another lawyer that I collaborate with, who said the decisions made by AI are not just perpetuating existing harms, they're actually creating new harms. Because if we think about, let's say, a mortgage lending, bias algorithm, we're saying that the training data that reflects existing norms of economic class and disadvantages and privileges are replicated into the decision of who gets to have a loan at what interest rate. And let's suppose that, a person who is disadvantaged now has a disadvantageous interest rate such and such that it perpetuates poverty. But then that data of that person having to take on and carry on the burden of heightened, economic burdens is going to be new training data for the future. And so it's not a perpetuation, it's a creation of new harms that are now derived from machines. And so I would argue that the harms really need to be better acknowledged. And it's, I don't know, 1 to 10. I have a lot of fear as a person, so I consider everything like 10. But I think there's a lot of hope in that. We as a society, we're getting a lot more intelligent, we're getting a lot more curious, and we have a lot of access to knowledge like this, like what we're talking about now, and how we will be able to look back at it. So there's more resources at hand than there was before. So maybe we'll have a better way to tackle it.
Thank you so much for that. Eric, I've got something for you from Benjamin Vava, who is saying, well, the new AI regulation is laudable, but there are also major problems, as both of you have alluded to. For example, the definition of AI, they're wondering, do we include moving averages? And then when thinking about data privacy and bias, techniques to protect individual privacy, for example, differential privacy, have been shown to directly harm underrepresented groups. So that's kind of a cue from the conversation we just had about unevenly distributed harms. And then actually, Benjamin's statement saying, well, the mitigation strategies, or at least strategies that are privacy preserving, are complicit with this. And they're wondering, how will regulators address this or prioritize harm reduction in that specific context?
Well, I think it's, again, a very good question. And these are really big problems. Probably the AI regulation will not come into force very soon. I remember well the process of creating the GDPR, and it took several years. And this new regulation may have may need a similar time. And one of the problems, there are a lot of problems. One of the problems is privacy, but we would say privacy is regulated by the GDPR, and other aspects like liability, that's regulated by the AI regulation. So probably the AI regulation will not take up this privacy issue. But the bias problem, Juyoun mentioned, that's a big point. And I would say a solution could be, so first of all, it's a very big problem. I would give it an 8, yeah, on the scale. But if you look at it closely, there may be ways to cope with the problem. One aspect is that human beings, of course, are biased too. What's the difference between a machine and the human being? Up to now, the machine is programmed by data. The data are biased. And as my colleague said, yeah, and therefore the outcome of the AI process is also biased. And this process, again, this outcome, because it's biased, may be part of the new data brought into the system. So it's a perpetuating process. If you realize this, then I think you can do something against it. A human being would also consider past cases when he or she has to make a decision. We are considering past cases and will formulate our new opinion on the experience of these past cases. But in addition, there's a kind of a normative layer, a value-laden layer. And when we see that certain groups are discriminated against, we would say, now we have to change things. And why not introducing such a normative layer into machines? It's a technical task, but I think it could be done. That could be a possibility. And in this way, maybe it's possible to tackle this bias problem. So I would agree, it's a big problem. It's a very, very big problem, but maybe there are possibilities to at least cope with it, or ameliorate, maybe the English word, yeah, to do a little bit, yeah, to make this problem not as big as it was.
Thank you very much for this, Eric. I have a super brief question for Juyoun, and then I have a closing question for both of you, which is because we have actually a thematic cluster with the remaining questions here. Juyoun, one question for you specifically is about the art litigation that you mentioned, and Yakuba is asking, if the artist didn't create the artwork and the AI created it, who created the AI, or which status has the creator of the AI in the specific project? If you could very briefly answer that.
It's certainly an open question with a lot of factors that need to go in, and something that needs to be determined by the Copyright Office too. But who developed the AI that then developed the artwork? Then the copyrightable portion would be like the algorithms and the programming software of the AI, but not necessarily the artwork. So there would be a difference in then what is, copyrightable or patentable or protected under intellectual property. So it would then become two distinct things that we're trying to cover under copyright. So the fast answer is that we don't know. Sorry, that's not very satisfying.
But it's accurate, I assume. So TBD, which is a kind of good summary of some of the conversations we've been having. Last question for both of you, and please take this as a sort of closing statement opportunity, perhaps not in a legal way, but in a public speaking kind of way. And we have a bunch of questions that are wandering or that are focused on the question about dynamic environments. So, basically treating society as a dynamic environment, treating technology as a dynamic environment or system, and the two together most certainly, but the law as a not so dynamic system. And the question that arises in that context is, how do we actually study context and change to understand issues such as discrimination in AI in that context? We have a bunch of questions around that. So if you could answer that and combine that with a response to what ideas, concrete ideas you might have in that regard, or concrete proposals. Eric, why don't you go first, and then Juyoun, and then we'll close.
I will try to do so. It's a complicated question. It's true that the technology is developing fast, society is developing fast. If we want to have regulation, if you want to follow this precautionary principle, we must do regulation in a rather abstract way. So when it comes to discrimination, one cannot mention all possibilities, but maybe a way of formulating it would be, it's not allowed to discriminate against people, and then the lawyers, it will be up to the courts and the lawyers to decide what discrimination means or not. This is the way it's done here in Europe, and on the whole, I think it functions. I totally agree with my colleague that this discrimination area is developing so fast that for a lawmaker, it would be impossible to formulate a law that is acceptable in 10 years to come. So that's one point. And another aspect is that I believe technology now is more or less the same all over the world, not only in America and in Europe, but also in Eastern Asia. And maybe this could be a good reason to try to find regulatory answers that are also international. And therefore, these discussions between US and Europe, but also between US and maybe Japan, Korea, China, and Europe and the US are very good, and we should go on with this and not just talk within Germany. Yeah, that's a big problem of German lawyers. They are kind of self-centered, and I have to say I profited from this talk very much, and I want to thank you again that I was invited.
Same, and I am very privileged to be speaking, and I learned a ton from you, Eric, and wow, wonderfully moderated by Mona, and thank you for the very thoughtful questions. I would love to continue, knowing more about the topics that are of concern to everyone who are participating here. I would just say that the first step, I think, that regulators and lawmakers could have as their ammunition is transparency, and the real visceral reactions from industry about not wanting to disclose anything about what's going on, and even the hurdles to getting to discovery in litigation as to anything that goes on, so to speak, under the hood. I think it's such an impediment to understanding what the harm is, the gravity of the harm and the scope of the harm, right? So if we don't yet know what the harm is, like, how do we even think about how to solve it and how to regulate it on a forward-looking basis? And so the need for abstraction, principle-based regulations and rules, and multi-jurisdictional type of efforts, interdisciplinary efforts. Those are all, I definitely echo that from Eric. At the same time, I think the immediate hurdle is transparency. How do we get more information about these things? How do we close that information gap? So, whatever ways we can think of to dismantle that wall, and other questions that we can raise, I would be very open to hearing from all of you. And if you can, please reach out and we'll talk more.
Thank you so much. And that is my cue to close us off with a heartfelt and sincere thanks to Professor Dr. Erik Higgendorf from University of Würzburg in Germany, and Juyoun Han, who is in New York. Both of them are online. You can find them and reach out to them, read their work, engage in a dialogue. I equally benefited enormously from this conversation. I learned a lot for myself, for my research, and for my classroom. So thank you for that as well. This conversation has been recorded, will be posted onto the IPK YouTube channel so you can watch it again. And please join us again for the next Co-opting AI event next month, which will be on agriculture. So I hope to see you again. Juyoun and Eric, thank you so much. And also thanks to Team IPK, and I hope to see you all very soon. Be well and take care.